Is there anything that we need to take up prior to starting the trial?
No, Your Honor. Correct.
Of Ms. Jensen?
Right, we have her here. She's present. We're ready to go.
Okay, let's bring her in, please.
She's here. Good morning, Honor. Ronald Manto on behalf of Kim Jensen.
Right, thank you. Good morning.
Good morning. I just wanted to put on the record.
Do you want to come forward?
Sure.
I was trying to pull up my transcript. Give me just a second, okay? I apologize. I didn't know that it was a proffer. I thought she was testifying, so I would have come out earlier.
No problem. And just for the record, Your Honor, my name is Jesse Dreicer. I represent Mr. Fernandez, who's present. Mr. Hill is present. Ms. Day is present. Ms. Nepstead is present.
All right, Mr. Mizrahi, if you could put the state of Florida's appearances on the record.
Christina Stifler, Alan Mizrahi, and Steve Siegel on behalf of the state.
Okay.
Okay, Judge. Yes, just based on the statement of particulars that were filed by the state on July 24th, I believe that Ms. Nelson would be in a position to invoke, but she's been served to testify, and therefore I believe she's under the protection of Florida Statute 914.
Well, my understanding of the case law is that she cannot just blanket invoke. So it has to be question by question. What is she going to testify to and what she's not? And then the court has to make a finding about whether there is any type of meaningful ability for cross-examination in order to determine if she would testify. That's my understanding of the case law.
Yeah, I think we're in agreement that the state is, based on the subpoena that we've provided the witness, that we are providing her immunity for her testimony and cannot use it against her. And therefore, she's going to be willing to testify. I think Counselor just wanted that on the record, that what she says cannot be used against her. And that's a true statement.
Therefore, she doesn't have to invoke for every question. We're in agreement that she's afforded the protections.
All right. So where is Ms. Jensen?
She's right here, Your Honor.
Okay. Good morning, Ms. Jensen. Come forward, please. Raise your right hand to be sworn in.
Ma'am, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, Ms. Jensen, before you take the witness stand, I'm going to have you kind of step back so that it doesn't, no. I mean, back outside when you're called as a witness, so it doesn't appear that there is something unusual going on. Most witnesses just come in from the doors. Do you understand? In just a minute. So I need to have a conversation with you, though. Give her a microphone, please.
And Judge, maybe a little bit of background as to what we expect is going to happen. Mr. Mizrahi is going to enter proffered evidence, and then unless there's a major changing in the court's ruling, I do not believe Ms. Jensen
Would not
be.
It's on.
Okay. All right. So, Ms. Jensen, first, let me make sure that you understand. Do you understand what your attorney is explaining to the court?
I do.
Okay. Which is what?
That I have
You have a constitutional right.
to invoke.
Right. And so the state is giving you a subpoena. So that means that.
I was forced to come here, not, right? Compelled.
Right, but you're compelled to come here.
Right.
But on top of that, more important than that, is that if they gave you that subpoena, that means that your testimony, since they're compelling you to talk, to testify, then you would have immunity as to the answers.
Yes.
Okay. So that's important to understand, because otherwise, if you did not have that, then they could possibly use this as some sort of information or statements to use against you. You understand that?
I do.
All right. So the second part of this is that this is a proffer, meaning that they're going to call you to the witness stand. There won't be a jury here. So I'm going to determine whether these questions would be asked in front of the jury or not. So what's important is that I try to explain this to witnesses because proffer means an offer of proof. So he's going to ask you some questions that he would want to ask in front of the jury. So I like to explain it to witnesses because you're like, why are they asking me the same thing again? It's because the jury's not here. The jury is the fact finder. Do you understand that?
I do.
And so I'm trying to make a legal ruling, all right?
Okay.
You've already been sworn in, so you can go ahead and take the witness stand. You can take the microphone away from her. There's one on the witness stand.
Thanks, Ron.
Do you want to take this?
So there's a slight incline here, okay?
I thought you wanted her to go out and come back in.
Did you want me to go back out?
No, not yet. You just have a seat. Right, Mr. Mizrahi.
Thank you. Please state your name for the record.
Kim Jensen.
And how do you know Shanna Gardner?
I initially met her probably 11 years ago through church.
And would you consider yourself close friends with Shanna Gardner?
Yes.
Have you had the opportunity to review a series of text messages that have been labeled State's Exhibit 10F for identification?
I did.
And are these some of the text messages that you and Shanna Gardner exchanged and you and Susan Lee exchanged?
They are.
That you're now enter this as a court exhibit.
All right.
Exhibit 1.
I'm assuming no objection to that for the court exhibit.
As a court exhibit, no objection.
Okay, can I see it? Thank you. You can proceed.
Thank you. So, Ms. Jensen, any of those text messages have to do with Shanna Gardner's ex-husband, Jared Bridegan. Is that true?
Correct.
Describe for the record how the divorce went and how the child custody went with regard to Shanna Gardner and Jared Bridegan.
From a legal standpoint, I guess the divorce went quickly, but it was not amicable at all. And the child custody was 50-50. And that was the ruling.
How did Ms. Gardner feel about Jared Bridegan as a father?
He frustrated her as a father.
And did Ms. Gardner share with you that she wanted to have more custody of her children?
Shanna wanted more communication more than anything.
Yeah. Does that include that she wanted more custody or no? Yes or no? Or I don't know.
I don't know.
I'm going to object to leading. She's free to answer the question on direct as she wishes.
I don't think giving 3 potential options of an answer.
I'll overrule it. Go ahead.
You would,
Sorry.
let me ask you this. In those text messages that have been entered as a court exhibit, did Shanna ask about a hitman?
Those were in the text message.
And based on that request, you texted another friend, Susan Lee, about finding somebody for Shanna. Is that fair?
That's not fair.
Okay. Well, what do the words say?
The words say that.
You've testified previously that you were joking about this. Is that fair?
Something that had nothing to do with Shanna, yes.
But you would agree that shortly after Shanna asked you for a hitman, that you then reached out to Susan Lee.
I'm going to object to leading again.
I'll overrule it for the purpose of the proffer, okay? So we can get through it.
Yes, ma'am.
I did reach out to Susan Lee.
And the words are what they are.
They are what they are.
Describe for the record how Shanna married Mario, what you knew about it, and then what your relationship was with Mario Fernandez.
How she married him?
Yeah, what did you know about it? Was it fast? Was it slow?
It was fast. She met him and then married him within just a few months. It was it was quick.
And what did you think about Mario Fernandez?
I thought she shouldn't marry someone so quickly because I didn't know Mario particularly, and I didn't think that she was ready to move on.
And do you see Mr. Fernandez here in court?
I do.
Can you say where he is so you can identify him for the record?
Right there in the blue suit.
May the record reflect the witnesses identified the defendant.
Yes.
So did you have conversations in the presence of Shanna Gardner about Jared Bridegan with Mario Fernandez?
Maybe. Most of my conversations were strictly with Shanna.
In your meeting with Mario Fernandez, did you think that he was a boastful individual?
I did.
Did you think he would brag about being able to do things that you believed he could not do?
I did.
And was that, just describe that a little bit more for us.
Mario was always a big talker. I always believed that he wanted to be the biggest person in the room. His personality was such that he always had a story about everything. He always had, he always knew somebody. That was his personality. He had a very big personality.
And did that big personality sometimes relate to his Navy career?
I think it was Army, but yes.
Okay. So he would talk about doing big things in the Army?
Yes.
Did then Shanna Gardner ever share with you statements that Mario made about being able to fix things, take care of things?
And just
Yes.
for the record, I'm objecting as the same objections that I've made in my motion to limine, Your Honor, that you've ruled on.
So just so that I'm clear, this is the objectionable part that you're indicating. There's no objection to the previous testimony? Just so I know that what I'm ruling on.
Yes, well, it's very complicated. There's going to be two separate things that I don't think any of that other stuff get to if this statement doesn't come in and your ruling stands. And I think Mr. Mizrahi agrees to that. Those conversations that Ms. Jensen just testified to, Mr. Mizrahi specifically said that Mario was present for. So obviously there's no marital privilege to that.
Right, so y'all keep doing this. A proffer is get to the objectionable part. So like
I'm
if
not
there
doing
is no, Mr. Mizrahi, if there is no objection to that, I've heard Ms. Jensen testify before. And so if you could get to the part that you believe I need to make a ruling on, that's what I'd like to get to. If there's no objection to this and other stuff, there's no need for me to hear it.
The state of Florida has to lay some background. This is not a situation where the witnesses testify and we've let the jury out. I have to let some background.
I agree.
So I spent 5 minutes laying a background, and now I'm
Longer
getting to
than
the
that.
questions.
Longer than that. Get to it, Mr. Mizrahi.
I am, Your Honor. I'm getting to the point now where that's why he objected. So,
I'm sorry, but just to be very clear, that court exhibit, Your Honor, would never come in, and we would object to that. But
Okay.
I got it. Move on. Mr. Mizrahi, go ahead.
yeah, just let me do it. So describe the things that Shanna Gardner shared with you about Mario being able to fix things.
That was his catchphrase. He would say that about all things, no matter what it was. If it had something to do with me, if it had something to do with the kids, that was just a common phrase that he would say.
And did Mario Fernandez share with Shanna Gardner that he could take care of, fix the issues Shanna Gardner was having with Jared Bridegan?
In a family law setting, he would say he believed that they could use the family law courts and fix the problems.
And so that's something that Shanna Gardner shared with you, that Mario says he can fix it, he can take care of it. In a family law setting is
Yes.
what your impression was.
Yes, that was my impression.
So did Shanna Gardner also share with you that he could take care of it because there was a motorcycle gang that was living in close proximity to Jared Bridegan?
When Shanna relayed that statement to me, it was I have eyes.
Okay, and that statement, I have eyes, has to do with Jared Bridegan.
I have eyes on the kids at all times, so yes, I guess.
Did Shanna Gardner share with you that Mario Fernandez shared that he was close on multiple occasions to Jared Bridegan?
I don't know that I remember that.
Did Shanna Gardner share with you that Mario Fernandez had eyes everywhere?
Yes.
Did Shanna Gardner say that Mario Fernandez said that there had been missed opportunities?
As
Far as taking care of the situation with Jared Bridegan?
I'm not 100% sure if those were the words.
Tell
Maybe.
me what you remember.
You're asking me to go through years. I just need you to be more specific, please.
Okay. Well, have you previously testified that there were missed opportunities with regard to Jared Bridegan? Have you had the opportunity to review your grand jury testimony?
I did,
Would you refresh your memory to look at it again?
please.
You have it.
When I say grand jury testimony, I really meant your hearing testimony. So would that help?
If you show me.
Look at page 76 of the hearing testimony. You can go up there.
So what was your question again?
Did Shanna Gardner indicate to you that Mario Fernandez said that there were missed opportunities with regard to Jared Bridegan?
I don't see those words here. Oh, well, maybe down here, maybe. That was a question.
What was your answer?
I don't see an answer here. I said, my answer is, I heard the whole hearing, so I did hear the statements. I don't see where I answered that question.
Well, if you keep going, you do. 18, 19, page 77, lines 18 through 25.
Depending on the question, I guess it's possible, but I don't think so.
Okay. Now, turning to page 78, lines 5 through 7, do you recall the statement? We'll just do it like that, it's quicker.
Okay.
That there was a delay based on COVID?
My answer was, I never said anything about a delay in killing Jared because I never had any knowledge of Jared being killed or planned to kill him.
And then lines 13 through 16?
Not long after that, Mario had made a statement that he never goes anywhere. Neither did anyone else in COVID. Like it just didn't seem. You know what I mean?
I'm going to ask you a couple more statements and then we'll be done. Do you remember a statement that was made shortly before Jared Bridegan's killing?
Can you be more specific?
Hawaii.
I remember talking to you about Hawaii.
Okay. Tell, for the record, and tell the court what you remember Shanna Gardner telling you.
Shanna told me that they were getting divorced and how they were going to go about that as far as the kids were concerned. And at some point, Mario asked her if she wanted him to take care of anything, and she said, Jared, and he said, or she said, absolutely not. I don't want anything to happen.
So say that again since you kind of mixed it up.
What did I mix up?
Take care of who?
He asked if there was anything Shanna wanted him to take care of, and she said Jared, and then she said absolutely not.
Okay, so who said Jared?
Shanna.
Okay, so I want to break down. Mario Fernandez says, is there anything you want me to do to take care of?
Correct.
And then she said Jared,
Yes.
and then Mario said okay,
Mario didn't say anything. She said no.
and then she said no.
She said absolutely not is what she said.
And this is what Shanna Gardner is relaying to you a week or so before the homicide.
I can't be sure. I told you originally that I wasn't 100% sure which trip that was, because every trip had something to do with divorce in the past, in the couple of years prior.
Right. You know when the murder was,
I do.
and you were aware of this statement a couple of weeks before the murder.
If it was that trip, but I said I couldn't be sure because there were many trips.
Okay. All right, Your Honor, that's all the questions I have.
Just so that I'm clear, and y'all can ask whatever questions you need to after the fact. So the Hawaii trip, when you said they are getting a divorce, you mean Ms. Gardner and Mr. Fernandez?
Yes.
Okay. All right, Mr. Dreicer. Sorry.
Ms. Jensen, good morning.
Good morning.
I only have a few questions for you. To be very clear, this is what Miss Gardner is telling you,
Yes.
a conversation that she had with her husband.
Yes.
You have no doubt in your mind that Mario Fernandez did not know that she was sharing these things with you, correct?
Correct.
And Mr. Fernandez you have never heard any of the words that you testified to regarding this last conversation, and most of your testimony, that Mr. Fernandez wasn't present for that. That's what Ms. Gardner was reporting to you that her husband told her, correct?
Yes.
And even that last statement, you don't know what Hawaii trip it happened on, do you?
I don't.
And there were many Hawaii trips, correct?
There were.
And divorce was something that was talked about from time to time with you and Ms. Gardner, correct?
Yes.
Regardless of how quickly they got married, Mr. Fernandez loved those children, right? That's what you believed?
I believe that.
He was an active and engaged stepfather?
He was.
And Mr. Mizrahi didn't ask you in those statements the questions in between all the different questions, but you would agree you kept telling Mr. Mizrahi that Mr. Fernandez just wanted to keep Ms. Gardner safe. That's what he was referring to in all those questions, right?
Yes.
I don't think I need anything else, Your Honor.
I just want to make sure, so the questions by the defense, those are specifically related to Hawaii? The Hawaii statement?
And all the other statements that Ms. Jensen said that Mr. Fernandez was not present for. That's what was
That's the problem. So I don't know that the defense needs to do it, but that is the purpose of the ruling. It's not necessarily all these statements. It's the circumstances surrounding the statements that.
I totally agree. That's why
I don't know anything about that to make a ruling. It's the circumstances for which the statements occur.
Circumstances under which the statement occurred, there's a state theory, two-pronged way why this comes up.
I understand the state's second theory, that it's about child custody. However, I want to be clear. I think about 45% of her testimony could be admissible. I find probably 3 statements that she couldn't make. I don't think that this is admissible. There are no circumstances for the court to make a ruling. However, the facts and the circumstances related to the Hawaii trip, I don't know, were they just made via witness to Ms. Gardner or vice versa on a telephone call? Was he sitting on the couch? That's what I mean, the circumstances.
It was a call between Shanna and I.
Shanna was in Hawaii when she.
I believe so.
Judge, there's no dispute. Mr. Mizrahi will agree with me. Mr. Fernandez was not present, and he did not know that she was ever going to share those communications. So there's nothing in your ruling that you heard today that's different.
Well, I want to be very clear. I did not say that she couldn't testify. Like I said, I think probably about 45%, but for these private text messages back and forth between, I don't know who some of these numbers are.
They're not.
But anyway, you're not. Okay, so I'm not making a ruling on that. You just want it admitted for what purpose?
On the court record, we didn't establish Kim Jensen, conspiracy, still Jared Bridegan. That conspiracy never ended. He completed, nor was there any voluntary renunciation.
So as it relates, hold on, let me pause you. As it relates to the co-conspirator statements that pass prior to her marriage of Mr. Fernandez, I'm not excluding that. Okay, so, but you're not admitting this? Okay,
Very uncomfortable concept that co-conspirator hearsay statements heard before Jared Fernandez even had these conspirators carries with it a potential due process confrontation issue.
okay. All right. So the state is, all right, so you're putting in a court exhibit that you do not intend to actually introduce as evidence. However, the statements, I only really see 3 potential problems with the admission of some of these statements. The Hawaii statement, a private conversation between this witness and
The Hawaii statement was the main purpose on doing all of this. That is why we went proper on Friday, that's why we put it on proper. People believe in marital, hearsay, statement.
all right. Thank you, Ms. Jensen. Do you have anything further for Ms. Jensen?
No. Can I have 1 minute with counsel?
Okay.
The state and I I think we understand, and it wasn't as clear, but I agree with the court. Anything that she heard Mr. Fernandez say, it would be admissible if the state so chooses to call her. I did not object every single time this morning because
Right.
I was trying to get through it. Most of what she testified to was just what Ms. Gardner told her, and the state agrees with me. They're not calling her to put any of that in. So just so the court's aware, I would have objected to every single question where she was reporting what Ms. Gardner told her Mr. Fernandez said. With that being said, I think the witness can be excused.
All right. Just temporarily so that I can make a ruling. Okay.
Okay.
Thank you. No. Thank you. So I wrote in the court's order the state's secondary theory related to Ms. Jensen. I've rejected that line of thought. I saw no support in the law nor the rule that would allow the state to submit that statement and pierce the marital privilege. I left open the potential that if there were circumstances surrounding the actual statement that would basically, the privacy would fall away, the circumstances for which it was made. But generally speaking, I believe that the exceptions to the marital privilege outside of the privacy area are well defined. It is a crime against either one of their children. AB and LB are Miss Gardner's child, but none of what I saw, and I'll hear you out, changes the court's analysis. So I'll hear you if you want.
Yeah, just very briefly, thank
Okay.
you. Your Honor. The AB and LB are victims of an intentional act that reasonably could lead to their physical or mental injury. Because this is not a murder that is done for a gang reason or for money reasons, and tangentially, those children are injured. The goal and purpose of this homicide was to take away Jared Bridegan's parental rights to eliminate their father intentionally. This was the intentional act done that could lead to their physical or mental injury. LB and AB are children of Shanna Gardner. Therefore, she has the ability, her statement pierces the marital privilege because it's a statement about the homicide involving her two children. That's the theory. The reason why we put on Mr. Ponder yesterday is it was direct evidence from the defendant's mouth to Mr. Ponder's ears that the purpose of this homicide, the purpose he hired someone to do this, was for child custody issues. So this isn't the act itself was an intentional act to inflict physical or mental injury upon these children, in addition to obviously Mr. Bridegan, but that was the goal of it. In order to prove a child abuse, the act has to be intentional. So the court's concerned that it was just some random act of violence. That would not be intentionally to the children. The court.
That's not my concern.
Okay.
What criminal case has ever centered on child abuse where the children are physically safe in their house and let's say the other spouse gets beat up, or let's say it's that, beat up by the other spouse, and then somehow that pierces some sort of marital privilege. AB and LB, I believe we all could agree, were safe, at home, dropped off, physically safe. So the mental argument by the state is that, I guess do you know a case where that's been the child abuse theory?
There are cases where the child abuse theory has been premised on mental injury, 100%. There is not a case that deals with child abuse that mental injury is the reason to pierce marital privilege.
No. Have you seen a child abuse case where one parent is trying to get custody over another parent and therefore the state of Florida intervened with criminal sanctions saying that, no, that's child abuse?
No. There is not a child abuse that I'm aware of, at least an appellate case, an opinion case, where the murdering or injuring of another parent for child custody.
I'm not talking about, let's say not murder. Let's say just a third-degree child abuse where the state of Florida goes and arrests another parent because they want more custody than another parent.
Well, that would never be a child abuse.
Okay, but that would be mental injury on the child potentially, right?
No.
Okay.
Talk about murdering their father.
All right.
It
What
has
about
nothing to do with
breaking their
legal-
legs?
Well,
Breaking their legs or doing something horrible to the other parent?
That doesn't interfere with their custody. They still have custody of their child if they're beaten up, if their legs are broken, if they go to the courts. That's all legal methods. You're talking about the only true way that they could eliminate custody, the only way they could take this father away from his children was to murder him. There is no other way. That's our theory, is that that was done intentionally, and that reasonably could lead to the children's injury. It's a very unique set of circumstances. Certainly, we don't have any third-degree child abuses under that premise because it wouldn't exist. We do have third-degree child abuses with an act that could intentionally lead to mental injury to a child. Those exist.
Quote me a case.
I don't have a case right off the top of my head. It's the statute, Your Honor. And there are certainly premises under the statute, under 8, I don't have the right book, under 82703, it says an act that reasonably could lead to the physical or mental injury of the child, and we have to be able to prove those elements. There's not a, I mean, I could probably find one. I don't have it at the top of my mind, because there's not one. I concur with the court. There's not going to be a case that says that pierces marital privilege. There are, and I submitted in our argument, cases where the reckless driving pierced marital privilege.
Right, but that was one parent that was driving and then injured the child. That's, in my mind, so factually distinct from this scenario.
I don't think the child was injured at all, Your Honor. If you read the case, the child was subject.
I've read a lot of cases very recently, so I apologize for getting it. But I believe that it related to the child. I'll pull it back up.
The child was in the car and the person was driving recklessly, and that could lead, that was considered a child neglect. It wasn't an abuse, it was a neglect. For failure to provide the care necessary for the child's well-being by driving recklessly while the child was in the car. I agree that was, the child was in the car when the recklessness occurred. But it doesn't change the state's argument that the intentional act was to eliminate the parental rights and take away these children's father.
That case also went to the premise of the psychopatient privilege. That's what the court was ruling on, not the marital privilege. They punted, or they didn't need to go to the marital privilege because they relied on the psychopatient privilege, which does not have the same elements as the marital privilege.
So there's a Florida Supreme Court case, Dufresne, Dufresne v. State. It's a Florida Supreme Court case, 826 Southern 2nd 272, that goes through, I guess there was a challenge to the phrase mental injury, where there was a constitutional challenge for vagueness, and it goes through the history where it falls. The Florida Supreme Court, it says that we note the definition of mental injury now found in 39, that's when they redid the statute, this is a 2002 case, is a limiting definition as opposed to a broad definition, which benefits the defendant. Thus, mental injury, as defined, will present only in limited circumstances, thereby discouraging arbitrary and discriminatory enforcement. Accordingly, pursuant to this analytical framework, which sets forth in Fuchs, we conclude that the district court properly held that the challenge statute is not unconstitutionally vague. Mental injury is adequately defined, is what it says, and I'll go back up to what they are affirming is not vague, which in 39, I know the state is focusing on the intentional part because your theory is that the murder is the intentional act that would somehow produce this, which is mental injury means an injury to the intellectual or psychological capacity of a child as evidenced by a discernible and substantial impairment in the ability to function within the normal range of performance and behavior. So you're saying that LB and AB, that is the fact. So I would need more facts there.
I understand the court's, I understand that law. I'm very well of the mental injury law and what is required. I would point, Your Honor, to Hill v. State, which I argued at our last hearing at 846 Southern 2nd 1208 is a 2003.
Repeat the last numbers.
I'm sorry. 846 Southern 2nd 1208. It's a 2003 5th DCA case, and under Head Note 5, 6, and 7, Your Honor, we don't have to prove beyond it to the exclusion of a reasonable doubt that a child abuse occurred. In fact, the court quotes, and I'll read it for Your Honor, although we have found no case in which the defendant has been convicted of this crime of child neglect based on reckless driving of a vehicle, if the defendant's reckless driving is shown to be sufficiently gross, there is no reason why the charge could not be proven. Because of the clear statutory language in both Section 39, which is what we're going on, we agree with the trial court that the psychotherapist patient privilege does not exist in this case as to any communications relevant to the child neglect felony count. So the law doesn't require you to prove.
I'm not putting that burden on the state.
I'm sorry, what?
I'm not putting that burden on the state. I don't want you to even argue that. I'm not putting that on there. However, I do have to find that that would be potentially a child abuse, correct? In some form. I'm not saying that you have to prove beyond a reasonable doubt
Right.
each and every element, and I don't want you to think that I'm doing that.
Okay.
And as well as I don't want you to put on an entire proffer of things that I probably about 80% I would allow. I'm not putting the state in a box like that. Instead, I don't know, just like the state is being cautious, saying that we don't want to put in evidence that there was a pre-existing conspiracy for confrontation. That's your choice. That's your strategic choice. However, I need a legal path to admissibility. Admissibility isn't beyond a reasonable doubt. So I want that to be very clear. I'm not putting that burden on the state.
Okay.
But I do, you would agree, Mr. Mizrahi, that this is unorthodox.
I wouldn't call it unorthodox. I would call it using the law to get in pieces of evidence. That's what I would call it. I wouldn't call it unorthodox.
All right. So Earhart is like my favorite book.
I love it too.
Okay.
I've seen him lecture many times.
Me too. All right.
You have.
Total fan club. However, I don't see that Earhart has anything. And
doesn't.
he is a guru on evidence that would even suggest a path like this.
My argument to the court's last inquiry about whether or not it is inconceivable that a 9-year-old child whose father has been murdered would not have some discernible psychological issues as a result of the elimination of that parent. This is not unorthodox or way out there. It is incredibly logical that if a child loses a parent, that they will be subject to some type of psychological damage as a result of it, discernible as required by Dufresne. So I think the court's analysis ends there. Is that reasonable? Yes, I think that's reasonable. Therefore, it pierces husband-wife privilege, and it is admissible. That is the state's argument. And if the court, I agree with the court that there is not a case on point, on all fours, that deals with this issue. I agree with that. I agree that with the reckless driving, the child is in the car. This is a mental injury situation as opposed to a reckless driving situation when the child is in the car. Those are two different scenarios.
Well, let me ask you this.
Can I?
I'm still messing. I've got to figure out what Mr. Mizrahi is, what his path to admissibility. And he keeps saying all these much higher hurdles that I'm not putting on the state.
Okay.
And so let me go ahead. What's your objection?
My objection is, and I've been quiet and letting the court and Mr. Mizrahi go, is that you made a ruling and you gave a pathway to the state to see if they could breach the marital privilege. And they put on their proffer. There was no breach of the marital privilege. And now Mr. Mizrahi is getting essentially now what's been 30 minutes of an opportunity to re-argue and start citing case law of cases you've already ruled on, you've already read, that is not what today's hearing was for. Your ruling was very clear. If they can breach the privacy, then you made the ruling. You've read Hill. You've read all these cases. So I'm just sitting here letting him get a second bite at the apple in the middle of the trial, and I think that's unorthodox. I think your ruling which was written, well thought, well written, and took time and days before we got a decision, is now just being relitigated on the very premise of not what you said they could do, which is break the marital privilege. And that is frustrating as I sit here and allow this to go on, but it's as you see fit, Your Honor.
So this is where I'm at. In that hearing, there was the opportunity to call these witnesses. It didn't happen. The state is able to make a record, which they're allowed to do, which is a proffer. And while I don't necessarily, generally speaking, proffers are the objectionable evidence, and their record needs to be clear, Mr. Dreicer, that generally speaking, the proffer only includes what is being objected to. Like I said, I don't want the appellate court to be under the impression that I ruled all of that inadmissible, which I did not. I don't want the state to make a record saying that I'm saying that it's not admissible because they have to prove something beyond a reasonable doubt. It is not. I know the rules of evidence. So I don't want, that is what I'm doing, okay? So as far as that is concerned, I have heard part of this. I haven't seen it in real life. I did not know what the purpose of Mr. Ponder was or what he was saying, I guess, at the very end. And then I want to make sure that the record, what you're objecting to is the Hawaii statement, and then some other statement that was made on the phone. But there were statements put in that apparently Mr. Fernandez was here for. And so that would not be marital privilege. That is not inadmissible.
Agree.
And so my last question for Mr. Mizrahi is that the statements that you were seeking to admit where you're saying it was related to child custody, you're depending on Mr. Ponder, not from Ms. Jensen, because she said that Mr. Fernandez said he was going to fix things through the family law system.
Well, it's both.
It's both. Okay.
It's both. The Ms. Jensen doesn't say that Mr. Fernandez said he was going to kill Jared Bridegan for child custody. That's why we put the Ponder on.
Okay.
The Ponder statement is the direct evidence that the murder was done with the intent to commit
Let's be
child abuse.
All right.
Mr. Ponder did not need to be proffered. I agree. You weren't making a decision as to whether what he could say comes into evidence. You were very clear about that, and I agree with the court. They just chose not to call Mr. Ponder for strategic reasons. They had no, Mr. Ponder.
They have?
Yes, they have chosen not to call him.
Okay.
And they brought him in to tell you evidence that the jury has not heard that could come in. He can say what Mr. Fernandez told him, and then I'll cross-examine him, and the jury will decide what they're going to do with Mr. Ponder. But now they're trying to get in what Mr. Ponder said to influence your ruling. When I don't know why they proffered it, quite frankly, I guess to stack inferences. But Mr. Ponder could have testified in front of the jury. He wasn't saying anything, as you said. You don't make determinations on believability. You make legal decisions. There was no legal objection that I know of that I could prevent Mr. Ponder from testifying. So let's be very clear about that.
Okay. Well, I didn't know the state wasn't calling him, so. All right. If you, Mr. Mizrahi, I stopped you because I thought he was going to testify and they'd hear all of that stuff. I needed to make a legal ruling. But if you wanted to put him on again to, I guess, or put his deposition in, I don't know. But I stopped you because I thought he was going to testify.
The state does not need to recall Mr. Ponder for any purpose of the proffer.
All right. So
We have put on the evidence that we think the court can make this decision, and we understand the court's previous ruling, and I've made my argument, so we're good.
all right. I'll maintain the ruling. Are y'all ready to get started?
Yes, Your Honor.
Ms. Jensen, you don't want her anymore?
Jensen is excused and needs to appear. And needs to appear for the Gardner case. And she's under subpoena.
Okay, thank you. Nice meeting you. Ready?
We'll see.
Mr. Hathaway, will you get that exhibit? Who's the state calling?
Fred Barton, Your Honor.
Thank you. Waiting for them to...